Hey business owners, welcome back to the channel where we break down complex business regulations and how they affect you. Today's topic is something that can directly impact how you hire workers, especially if you rely on independent contractors. The Department of Labor has just made it harder to classify workers as independent contractors, and this new rule could mean big changes for your business. Let's dive in and see what's really going on. The US Department of Labor has implemented a new rule that makes it more difficult to classify workers as independent contractors. Before this rule, businesses could more easily hire workers as contractors, which meant no need to worry about paying overtime, benefits, or adhering to minimum wage requirements under the Fair Labor Standards Act, or FLSA. But now, under this new rule that took effect in March 2024, businesses must go through a complex six-factor test to determine whether a worker is really an independent contractor or should be classified as an employee. And let me tell you, this test isn't straightforward. So what are these six factors and how do they affect you? Let's break them down. Opportunity for profit or loss. Independent contractors have the ability to make a profit or suffer a loss based on their own business decisions. For instance, they can negotiate their pay, hire their own staff, and invest in marketing. If your worker doesn't have this freedom, they may be an employee. Investment in facilities and equipment. Independent contractors usually provide their own tools, equipment, or workspace. If your business provides these, it points to an employee relationship. Permanency of the relationship. If a worker has a long-term continuous relationship with your business, they're more likely to be an employee. Contractors usually work on a project basis. Nature and degree of control. If your business controls how, when, and where the worker does their job, that's a sign they're an employee. Contractors should have the freedom to decide how to achieve the results. Integration into the employer's business. Is the worker's role central to your business? If their work is part of your core offerings, it leans toward employee status. Skill and initiative required. Does the worker use specialized skills and business planning to grow their own business, or are they dependent on your company's training and oversight? Skilled, self-sufficient workers are more likely to be classified as independent contractors. The tricky part? No single factor is determinative. All six need to be considered, and that's where things get complicated. You need to weigh all the factors based on the individual relationship you have with each worker. Now, why does this matter so much for your business? Well, if you misclassify a worker as an independent contractor when they should be an employee, you could face serious consequences. Under the Fair Labor Standards Act, businesses are required to pay overtime and minimum wage to employees. If the Department of Labor or a court finds you misclassified workers, you could be on the hook for back pay, overtime, and liquidated damages, going back up to 3 years if the misclassification was intentional. If the ititas. Imagine having to pay thousands of dollars in back wages and penalties for each misclassified worker. That's why getting this classification right is critical. As if things weren't complicated enough, there's no one standard test. The Department of Labor's new test is just one of many. The IRS, for example, uses a different right to control test, which focuses more on whether the business controls how the worker performs their job. Meanwhile, some states, like California and Massachusetts, use an even stricter ABC test. This means that a worker could be classified as an independent contractor under the IRS, but be considered an employee under the Department of Labor or state laws. The inconsistencies make it difficult for business owners to navigate these classifications, especially if you operate in multiple states. So what can you do to protect yourself and your business from misclassification risks? Here are a few steps. Review your contracts. Make sure your independent contractor agreements clearly state the worker's independence and include clauses that highlight the contractor's freedom to control their work. Audit your workforce. Conduct regular audits of your workforce to ensure you're correctly classifying workers under both federal and state laws. Invest in documentation. Maintain thorough documentation showing that your independent contractors meet the six-factor test. Keep records of things like payment terms, project scopes, and any business investments your contractors make. Consider hiring corporations or LLCs. Although not foolproof, hiring contractors who operate as corporations or LLCs can increase the likelihood that they'll be classified as independent. By taking these precautions, you can reduce the risk of costly misclassification claims and keep your business in compliance. To sum it up, the Department of Labor's new rule makes it harder to hire independent contractors, and misclassifying workers could lead to significant penalties. By understanding the 6-factor test, regularly reviewing your contracts, and maintaining solid documentation, you can protect your business from these risks. Thanks for watching. If you found this video helpful, make sure to hit that like button, share it with fellow business owners, and subscribe for more tips on navigating business regulations. Have questions about worker classification? Drop them in the comments below, and I'll be happy to help out. See you in the next video.